My name is Raina Lloyd, and I am a juror in this courtroom drama. In this case, the plaintiff is patient Jackie Jones versus the defendant Ashford Hospital. The controversy within this case is that Beverly, who is a nurse with the Ashford Hospital, left a detailed phone message with the patient's daughter that included private health information consisting of results and diagnosis. I am citing on behalf of the plaintiff, Mrs. Jackie Jones, patient, because I agree that this disclosure of patient information was inappropriate, unnecessary, and unethical. The context of the communication and the detail of the disclosure of patient information doesn't follow Ashford Hospital's new message policy, under which Beverly should have simply left contact information and a request for a callback. Any extensive disclosure should have been a vague reasoning for the call. I also believe that this was a clear violation of HIPAA, the Health Insurance Portability and Credibility Act, and I don't believe that this followed the Patient Bill of Rights. And I will further explain these three key issues and violations in further detail. The inappropriate use of this disclosure. An article I found researching HIPAA and privacy rule stated that the disclosure of protected health information occurs when it is provided to a person not involved in the patient's treatment and care coordination. People who do not require the information to perform their treatment activities, or in situations where disclosure is not in the best interest of the patient. Key issues with this are that the lack of consent for the patient choosing how her health information is disclosed and to whom. There was no medical release of information, no consent, and this did not follow any patient requests. Beverly took this amongst herself and made her own decision. It also says that a nurse is obligated to protect the confidential information about patients unless required by law to disclose the information. Again, Beverly decided to do this on her own accord. Under the privacy rule for HIPAA, this requires appropriate safeguards, which can be distinguishable among different companies and organizations and their networks. But they are all set in place to ensure patient rights of health information and set limits on the conditions and on the uses of disclosure that may be made without patient authorization. And the safeguards under the privacy rule require, as with other requirements in the privacy rule, they establish protection for private health information in all forms, paper, electronic, and oral. So again, I believe this was a clear violation of our patient's rights. She is supposed to, under the Patient Bill of Rights, have the right to confidentiality of communications and records. She should have had a say-so and been asked, first and foremost, who this information can be disclosed to and who it cannot be. The information and the decision should be held in the patient's hands. No one else's, especially not the provider or the organization providing care. The context was not assessed by the nurse, the environment was not assessed, and the appropriateness was not assessed. This patient's daughter did not need to be involved in the treatment, did not need to be involved in the results or the health information reception of information. And also, our patient could have suffered from a lack of information about her own results from her daughter. The game of telephone is a simple concept to relate to, and this should have been done much more professionally, much more ethically, and I can't believe that this even occurs. Thank you.